Well, friends, if we cared about or chose to remain loyal to the text of the Constitution, then by all rights, January 6th should be Trump Disqualification Day. But do we really expect it to be? Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, as January 6th Election Certification Day approaches, let's have one more go at the 14th Amendment's disqualification of an insurrectionist from being sworn in as president, academic discussion though this may prove to be. I want to start by reading a short piece that ran in The Hill a few days ago, authored by two lawyers, each of whom was previously a clerk at the United States Supreme Court. Headline: Congress has the power to block Trump from taking office, but lawmakers must act now. And that article begins, "The Constitution provides that an oath-breaking insurrectionist is ineligible to be president. This is the plain wording of Section 3 of the 14th Amendment to the Constitution. Quote, no person shall hold any office, civil or military, under the United States or under any state who, having previously taken an oath to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. This disability can be removed by a 2/3 vote in each house. Disqualification is based on insurrection against the Constitution and not the government. The evidence of Donald Trump's engaging in such insurrection is overwhelming. The matter has been decided in 3 separate forums, 2 of which were fully contested with the active participation of Trump's counsel. The first fully contested proceeding was Trump's second impeachment trial. On January 13th, 2021, then President Trump was impeached for incitement of insurrection. At the trial in the Senate, 7 Republicans joined all Democrats to provide a majority for conviction, but failed to reach the 2/3 vote required for removal from office. Inciting insurrection encompasses, quote, engaging in insurrection against the Constitution or giving aid and comfort to the enemies thereof, the very grounds for disqualification specified in Section 3. The second contested proceeding was the Colorado 5-day judicial due process hearing, where the court found by clear and convincing evidence that President Trump engaged in insurrection as those terms are used in Section 3. The Colorado Supreme Court affirmed. On further appeal to the U.S. Supreme Court, the court held that states lack the power to disqualify candidates for federal office and that federal legislation was required to enforce Section 3. The court did not address the finding that Trump had engaged in insurrection. Finally, there's the bipartisan inquiry of the House Select Committee to investigate the January 6th attack on the United States Capitol. More than half of the witnesses whose testimony was displayed at its 9 public hearings were Republicans, including members of the Trump administration. The inescapable conclusion of this evidence is that Trump engaged in insurrection against the Constitution. In particular, Trump unlawfully demanded that his Vice President, Mike Pence, throw out votes in the Electoral College for political opponent Joe Biden, a power he did not have. While the riot was in progress, Trump used Pence's rejection of his demand to further inflame the crowd and cause them to chant, "Hang Mike Pence." Now, some will argue that the Supreme Court decision in the Colorado case, Trump versus Anderson, precludes or prevents Congress from rejecting electoral votes when they convene on January 6th on the basis of the 14th Amendment disqualification. This view lacks merit for three reasons. First, the majority's suggestion that there must be new implementing federal legislation passed pursuant to the enforcement power specified in the 14th Amendment is what lawyers call dicta. Dicta are the musings of an opinion that are not required to decide the case. The holding that Section 3 is not self-authenticating may be an alternate holding, but thoughts about the kind of implementing statute required are plain dicta. Dicta are not precedential. The four dissenters in the Supreme Court opinion strenuously objected to this part of the opinion as overreach by the majority, the five majority justices, overreach to decide a question not presented. This overreach is a power grab, which Congress is not required to credit. Second, counting the Electoral College votes is a matter uniquely assigned to Congress by the Constitution. Under well-settled law, this fact deprives the Supreme Court of a voice in the matter because the rejection of the vote on constitutionally specified grounds is a non-reviewable political question. Third, specific legislation designed for this situation already exists. The Electoral Count Act was first enacted in 1887 and later amended and restated in 2022. That statute provides a detailed mechanism for resolving disputes as to the validity of Electoral College votes. And friends, here is probably the most important passage. The Act, the Electoral Count Act, specifies two grounds for objection to an electoral vote. One, if the electors from a state were not lawfully certified, of course we saw that in the Trump fake elector scheme last time he tried to steal a presidential election in 2020, but that doesn't really apply this time. Or two, if the vote of one or more electors was not regularly given. A vote for a candidate disqualified by the Constitution is plainly in accordance with the normal use of words not regularly given. Disqualification for engaging in insurrection is no different from disqualification based on other constitutional requirements, such as age, citizenship from birth, and 14 years residency in the United States. Now, here is the procedure that would be involved if members of Congress decided to object to certifying the Electoral College count. To make an objection under the Count Act requires a petition signed by 20% of the members of each House. Then, if the objection is sustained by majority vote in each House, the vote is not counted, and the number of votes required to be elected is reduced by the number of disqualified votes. If all votes for Trump were not counted, Kamala Harris would be elected president. Now, friends, this last paragraph is where the rubber meets the road, at least procedurally, because disqualification of an insurrectionist from being sworn in as president would require at least some Republican participation. The unlikelihood of congressional Republicans doing anything that might elect Harris as president is obvious. But Democrats need to take a stand against Electoral College votes for a person disqualified by the Constitution from holding office unless and until the disability is removed. No less is required by their oath to support and defend the Constitution. Okay, friends, let's do a quick recap. The 14th Amendment, Section 3, clearly, expressly, and unambiguously disqualifies, prohibits an insurrectionist from holding office. Donald Trump is an adjudicated insurrectionist. Therefore, he should not be permitted to be sworn in, to hold office, unless, as the Constitution provides, there is a 2/3 vote in each of the houses of Congress, the House of Representatives and the Senate, and 2/3 of the members of Congress and the senators vote to remove the disability, the disqualification. Then he can be sworn in, notwithstanding the fact that he engaged in insurrection. That's the way the Constitution was written. But 5 Supreme Court justices said, no, we're not happy with the text of the Constitution. We're going to engage in overreach. We are going to build in an extra layer of Trump protection and require brand new federal legislation to be enacted before insurrectionists can be disqualified, which those 5 justices knew would never happen. Those 5 Supreme Court justices did real violence to the constitutional construct of things, to the constitutional order of things, when they decided to substitute their own language for the text of the Constitution. Donald Trump is an adjudicated insurrectionist twice over. In the Colorado trial court, where Donald Trump was represented at trial, and the judge concluded by clear and convincing evidence he engaged in insurrection against the Constitution. That finding was affirmed by the Colorado Supreme Court, and when that finding went up to the United States Supreme Court, they did not reject it, they did not undercut it, they did not set it aside. So, by their silence, they affirmed that very factual ruling. Donald Trump was also found to be guilty of incitement of insurrection by the United States Congress, the body that 5 justices say they had to act, they had to do something, they had to announce that they believe Donald Trump was an insurrectionist. Well, for God's sakes, they already did in the second impeachment of Donald Trump, at which Donald Trump was represented by a team of lawyers. The House of Representatives voted on and passed a single article of impeachment, incitement of insurrection, and they did it by a healthy majority vote that included Republicans, 232 to 197. And then they passed that article of impeachment on to the Senate for a trial, and the Senate found him guilty by a significant majority vote that, again, included some Republican senators, 57 to 43. In a very real sense, they said, you're damn right he engaged in incitement of insurrection. Now, they didn't meet the requisite 67 votes, 2/3, to remove him from office, but they sure as hell found him guilty by a healthy majority. Congress has spoken. Congress has acted. They found Donald Trump is an insurrectionist. No, the Supreme Court wants more. So they issued this dicta, this thought experiment, these ramblings, these musings that were not part of the holding in the case because it wasn't necessary for them to reach that question in order to resolve the case. Here's the thing, friends, and maybe you would be surprised to hear this from me. I actually don't quibble with the Supreme Court deciding that the state of Colorado could not keep Donald Trump's name off a presidential primary ballot because he engaged in insurrection. Why do I say I don't quibble with that? Because when you read the 14th Amendment, it doesn't say that if somebody takes an oath to support and defend the Constitution and thereafter engages in insurrection, states may leave their name off a presidential primary ballot. That's not what the 14th Amendment says, and that's all the Supreme Court should have decided. But instead, they went through this thought experiment saying, we'd like to see some new federal legislation before Congress can disqualify an insurrectionist. What absolute nonsense and dicta and musings and legal navel-gazing and thought experiment. None of it necessary to decide the Colorado case, and that's why those 4 justices so strenuously objected to what the 5-justice majority did when they built in that added layer of Trump protection that was contrary to the expressed language of the Constitution. Friends, let's get down to brass tacks. First of all, I know what I would do on January 6th if I were ever in a position and I were ever called upon to say, do you object or do you support? Do you vote in favor of certifying the Electoral College votes for an adjudicated insurrectionist? My whole life, I took my oath of office damned seriously. I took the oath several times, starting back in the 80s as a United States Army officer. When I left the Army and joined the Department of Justice, I took that oath again. I swore to support and defend the Constitution against all enemies, foreign and domestic, and I would not be upholding that oath if I were in a position to vote whether an adjudicated insurrectionist should be allowed to serve in federal office, never mind the highest office in the land. I couldn't in good conscience vote in favor of an insurrectionist becoming president. That would violate my oath of office, and I wouldn't hide behind the Supreme Court musings and ramblings and dicta, saying, gosh darn it, we know the Constitution doesn't say it, but we'd like to see some new federal legislation, which, psst, it's never going to happen. We know it's never going to happen, but let's just put it in there. But friends, let's be honest. What should happen and what will happen, as different as night and day, as different as black and white, as different as dictatorship and democracy. What will happen is Donald Trump is very likely to be certified as the next president of the United States. What should happen is politicians should rise up, should respect their oath of office, and should vote that an adjudicated insurrectionist is disqualified from holding office again. Because justice matters. Friends, as always, please stay safe. Please stay tuned. And I look forward to talking with you all again tomorrow.